This is Judge Herb Dodell. Last time we talked about restraining orders, and I was thinking about it. Employers really should think about using this methodology to protect themselves against liability. If they have information which leads them to believe there's a threat of violence at the workplace, and that includes counties, cities, states, any place, then they should get a restraining order. If they don't, and they had this information, and that person ultimately does do something dangerous and causes damage to other people, and they knew about the potential and didn't do it, they're exposed to liability. So by using restraining orders, that's a way to insulate themselves from liability. As I just mentioned, I have on many occasions issued restraining orders to the cities and the counties. In fact, one of the cases, City of Los Angeles versus Garber, not Garver, Garber, they took it up on appeal when I granted the restraining order, the respondent did, and it was affirmed on appeal by the Court of Appeals. So if you look at my book, From the Trench to the Bench, available on Amazon, you'll see an actual copy of the opinion from the Court of Appeals. Another thing to keep in mind is that these restraining orders can be modified. There have been occasions where people have come back and they usually grant it for 3 years. That's the term of the usual restraining order. Now, there's a difference between civil restraining orders, which is stalking, civil harassment, and the like, and domestic violence. Mainly, it deals with the burden of proof. A burden of proof means a party has to convince the court by this burden, more likely than not, which is the usual standard. But in restraining order cases in California, it has to be by clear and convincing evidence, which is a burden between more likely than not and the criminal standard of beyond a reasonable doubt.